Mr. Canfield, you are on the verge of contempt. You are maligning the court. I'm trying to be as diplomatic as possible. I'll blue pencil the son of a bitch today.
You cannot, Judge. It's more than 30 days have gone by.
Well, then I'll just refuse to enter the quadro, because now this is a horse of a different color. Judgment of dissolution in this case was entered on April 30, 2025. A few months later, on September 10th, Mr. Canfield filed his original motion for sanctions. On February 4th, the parties appeared, indicated that his client was not in agreement because it referenced surviving spouse provision that bothered him. As far as I can tell from the record, that was the only explanation ever given to the court, which is coming on now a judgment, a marital settlement agreement that was entered 10 months ago. Mr. Canfield, it's your motion. You go first.
The marital settlement agreement provides specifically, wife is awarded any survival benefits as may be available. That was the order of the court. All we're asking for is for the quadro to follow the order of the court, which was an agreement at that time. It was not a contested hearing. It was an agreed prove-up. So at that point, Mr. Gibbs had agreed to the terms contained. He then later changes his mind. I don't think he can do that. It's done. The court order's been entered, and all I'm doing is trying to enter a quadro in conformance with the order of the court.
Why is this provision about whatever surviving spouse benefits are available so important?
All I'm asking is conformance with the order. It says wife shall be awarded 50% of the value of husband's 401k, 50% of the marital portion of pension, and including any survival benefits as may be available.
And I'm not going to say that hasn't been in orders I've signed before, but it seems like it doesn't really mean anything. What survival benefits are conveyed with the 401k?
Well,
because you're not doing anything but naming an alternate payee. But unless she takes her payment and rolls it over into a rollover IRA, she's going to pay income taxes. She's going to pay penalties.
So?
Well,
that's not before the court. That is not before the court.
Well, wait a second.
No.
I'm not going to award sanctions if it's meaningless.
It is not meaningless.
Superfluous. Well, then just tell me what it means.
It means that if Mr. Gibbs passes, she is going to receive any death benefits that are awarded to a surviving spouse. That's what it means.
On a 401k?
On his pension.
Okay, so if he named her as the beneficiary to his 401k, does that mean he's not allowed to change her as the beneficiary?
That is correct, Judge.
There's a separate quadro for the 401k, and that was agreed and entered. And as far as I know, the 401k has already been divided.
Okay, what plan are we talking about?
Talking about the pension, Judge.
Okay, so her benefits, is he receiving his pension?
Yes.
Okay, and is she the beneficiary? Are there surviving spouse benefits?
Yes, he made the election prior to his awareness of the divorce being, that there needed to be a divorce.
Well, isn't he stuck then?
He is.
How long were these two people married?
A little more than 4 years, Judge.
4?
Yes. My client worked at Chrysler for 30 years.
Why is she getting half of his 401k?
The benefits of Chrysler have changed several times during my client's working there, and the 401k actually didn't begin.
Until they were married.
Correct.
So there's not much in the 401k.
Correct, Judge. We were never fighting over the 401k. In fact, I mean, this isn't something I've come across in my practice before, and recently.
I will tell you that I'm sure it exists. I would say that it's unusual for it to happen when there is not a longer marriage. in context, it doesn't appear that the attorneys in drafting this document used boilerplate. The result is that, I'm going to be honest with both counsel, I was not prepared to make a finding on whether this MSA is ambiguous. But under the totality of the circumstances, where they were only married for 4+ years, where it's got that parenthetical reference to death benefits, I think there's clearly a question. Maybe it clearly was her intent. Maybe Mr. Canfield and his client knew damn well what they were doing. Maybe it, as you said, went by you without question in the drafting because it wasn't something you'd encountered before. I don't really know, but it's starting to sound that there clearly was not a meeting of the minds on this provision of the MSA.
Not true, Judge.
Judge,
Okay, hold on. Mr. Canfield, why is that not true?
Because the order was entered with both parties present, both parties signed it, both parties reviewed it with their attorneys. So when you now...
I entered it, and I'm sitting here today looking at it telling you I don't know what it means.
All right, so are you telling me every single time we have to present you with a marital settlement agreement?
Mr. Canfield.
Then explain to me why the court, when it enters in order, now comes back and says, well, wait a minute, I didn't understand that order.
Mr. Canfield, you are on the verge of contempt. You are maligning the court. And the fact of the matter is, I'm trying to be as diplomatic as possible in saying that the court, one, has there is nothing on the court that requires it to go through a marital settlement agreement sentence by sentence to make sure that the attorney did a good job. All right? Or to question the parties as to what was intended by the parties.
I agree.
For me to say to you today, I don't understand what this provision means, is not my fault. It's yours. It's yours. And I will tell you that in the context of this marital settlement agreement, with a 4-year marriage, with neither party going in having an understanding of what the death benefits available were, or even making inquiry as to the nature of the death benefits or what they meant, slapping a parenthetical clause into a quadro agreement is hardly clear intent. So, you, Mr. Canfield, have the benefit of a lot of times in front of this court, in front of all of the courts in this circuit, and experience and knowledge. But this time, you need to calm down. I'm going to ask what, if anything, either of the parties would like to do now that you find yourselves in this fix, because I'm certainly, after what I've heard today, not going to award sanctions.
At least enter the quadro order.
Why would I do that?
Why wouldn't you?
Because that gives you what you want.
Yes, because we believe we're right.
I don't want it.
I understand, but I don't believe, based upon the marital settlement agreement, that he has a right to come back and redo the agreement. Third day, the final and appealable order.
Okay.
Order.
I am not going to order that quadro.
Now, if you're going to deny my motion, then we'll go forward with whatever we need to do.
Okay, well, I'm asking you, what do you think that is?
I don't know. You're the court. You tell me.
Well, Mr. Canfield, it sounds to me like it's going to take some parole evidence to figure out what both of the parties knew, wanted, or anything, or I'll just, if you tell me that you don't have anything else to offer other than what you offered today, I'll just reform it today.
I do not understand what the court means.
That I don't know any other way to put it. I'll blue pencil the son of a bitch today if you don't want to produce anything else in terms
What do
of...
you mean blue pencil?
I'll change the terms of the MSA.
You cannot, Judge. It's more than 30 days have gone by.
Okay, well then I'll just refuse to enter the quadro. Unless the parties can come to an agreement as to what the quadro should say.
If you make a final and appealable order, then we will proceed as required.
So you would put the burden on Mr. Ainsworth to file the appeal.
Yes?
She's already receiving the marital portion of the benefits?
Correct.
Not. She's not. Quadro's not entered yet, so therefore the money is all going to Mr. Gibbs. She's not receiving it.
I mean, retroactive from the date of the...
It is, Judge. But until that quadro is entered, she doesn't get a dime.
Okay.
So this entire time period, almost a year, she's not received those pension benefits.
Okay.
See, I don't see any option, Judge, because here's the problem. There's only two spots that I can choose on that pension quadro form. One says she doesn't get any, and the other says she does get any.
Well, there's a third.
I don't find a third.
The third spot is that she gets 20% or whatever it is.
You have the form before you. Tell me where on the form I can put that.
You could probably write it in there anywhere. Just because you can't put it on the form doesn't mean it's not a term. Did the attorneys ever discuss with each other, I'm not asking for attorney-client privileges, this particular provision?
Should I answer that, Judge?
Either one of you.
I don't believe we did.
Yeah, and that's what it comes down to.
The survivor benefits were not any part of any of the settlement negotiations. Settlement negotiations are not supposed to be. I mean, I think this is maybe what you were referring to about parole evidence a minute ago, but it was not something that we had extensive conversation.
Or any conversation about, apparently. But you read that.
I did.
And did you inquire?
My client inquired of the pension company.
Well, but
I did
what?
not inquire of Mr. Canfield.
Did you ask the pension company, what does this mean to you?
My client did.
And what did they say?
They said that it was ambiguous, Judge. They agreed with you. They said that it meant that they would interpret it to mean any future spouse, any current spouse at the time of his death would be foreclosed from any death benefit whatsoever, and that petitioner in this case would receive the entire death benefit.
Well, that means they understood it to mean what Mr. Canfield is arguing.
That's not what my client understood it to.
Well, wait a second. The company told your client that the way this is written, the way we would interpret it if we had to pay it out, is that if he remarries, your client gets nothing. Is that what they said they interpreted it at? Because now this is a horse of a different color.
They were reading it in
No, Mr. Ainsworth, now you be, and I got miffed at Attorney Canfield, but this is not something that was mentioned. What did the plan administrator, through your client, tell you?
the MSA taken with the quadro as drafted resulted in
But the quadro as drafted, I'm going to guess, did not have box 2 checked.
It did.
It did, but they're going to follow what the Quadro says, regardless of what the MSA says.
What they started talking to him about immediately was the paragraph C that I did not completely address, which they said that they deal with this and that there are times when the survivor's benefit is divided, but the way this is drafted is not one of those.
Okay, stop right there. So they told you the way they read this is she gets the entire survivor's benefit.
Which was not my client's intention.
The MSA. Wasn't your client's intention, but Mr. Canfield has been saying all along that was his intention, and then you got an opinion from the plan administrator which said that's the way we read it too. Isn't that a horse of a different color? Did I say that twice now? You had guidance from the plan administrator on what the MSA meant.
Well, that's when we knew we had a problem, Judge. I mean, that this is not.
All right, Mr. Canfield, in light of what I was just told, I will enter an order that the Quadro be entered indicating that your client will receive the death benefit upon Mr. Gibbs' passing and that he cannot designate an alternate payee. I'm troubled by the fact that we could have shortened this whole process. I'm going to ask that that order be submitted, and I'll give you 14 days to get it on my Odyssey proposed order queue, and I will deny the motion for sanctions. That's it then.
Thank you, Your Honor.
Thank you.
And Judge,
Yeah.
I apologize if I got too tough.
Well, that's your MO, Mr. Canfield.